India and Pakistan may disagree on almost everything. Their governments may stand on opposite sides of the political divide. Their armies may face each other across one of the world's most heavily guarded borders. But sometimes, when an ordinary human problem reaches the highest court in the land, something remarkable happens. The judges on both sides of the border seem to be asking almost the same question. Can you accept one date of birth for your entire career, and then challenge it when retirement is finally approaching? And this story becomes even more fascinating because, in India, the person involved was the chief of the Indian Army. In Pakistan, it was a government officer. Different countries, different ranks, different courts, but an astonishingly similar legal problem. At the center of the Indian controversy was General V.K. Singh, then Chief of Army Staff of the Indian Army. His official records carried one date of birth. But General Singh maintained that the correct year of his birth was 1 year later. His explanation was, in essence, a very human one. The mistake had occurred when his date of birth was originally recorded, and his parents had not ensured that the correct date was entered in the records. But there was a complication. This dispute did not become a major legal battle when he was a young officer. It became critical when he was approaching the end of his military career.
Why?
Because 1 year could mean one very important thing. 1 additional year of service. And that meant the dispute over a date of birth was no longer simply about a document. It was about the length of his tenure as India's army chief. The controversy eventually reached India's highest court. And the question before the judiciary was much bigger than General Singh's personal claim. It was essentially this. If a date of birth has been accepted and acted upon throughout a person's career, can that record be changed at the very end of the career? The court had to look beyond the sympathy of an explanation. Because if every employee could challenge his date of birth shortly before retirement, the entire system of public service records could become uncertain. And there was another important consideration. The person asking for the change was not an ordinary employee. He was the chief of the Indian Army. Yet the law could not simply be rewritten because the person involved occupied one of the country's highest offices. Ultimately, General V.K. Singh's challenge did not produce the additional year of service he was seeking, and he eventually withdrew his petition. And that brings us across the border. Because something strikingly similar was happening in Pakistan. Now forget the army chief. Forget the military. Forget the enormous public office. The Pakistani case involved a government officer. Secretary Excise, Taxation and Narcotics Control versus Muhammad Abdullah Khan, 2026 SCP 162. Here again, the controversy concerned the officer's date of birth. 4 years, his service career had proceeded on the basis of the existing record. But when retirement approached, an attempt was made to have the date of birth altered on the basis of another document. And, just as in the Indian controversy, changing the date could have a very important consequence. More time in government service. The Supreme Court of Pakistan was therefore confronted with a question remarkably familiar to the one that had arisen in India. Can a settled service record be reopened at the very end of a career? The Pakistani Supreme Court said, in substance,
No.
The court relied upon principles including estoppel and acquiescence. In simple language, if you have accepted a particular position for years and taken the benefits of that position, you cannot suddenly reject it when changing it becomes personally advantageous. And now the two stories can be placed side by side. In India, the person at the center of the controversy was General V.K. Singh, the chief of the Indian Army. In Pakistan, it was Muhammad Abdullah Khan, a government officer. The rank was dramatically different. The institutions were different. The countries were different. Yet the judicial concern was remarkably similar. The courts were protecting something bigger than the individual claim. They were protecting certainty in public administration. Because a government service record cannot be treated like a document that can simply be rewritten whenever retirement approaches. If a person accepts one date for decades, and appointments, promotions, benefits, and service decisions are made on that basis, allowing a last-minute change can affect not only that individual, but the entire structure of public service. And this is where the story becomes bigger than India and Pakistan. The principle is actually very simple. Your own long-standing conduct matters. You cannot enjoy the benefits of one position for decades and then, at the moment when another position becomes more beneficial, suddenly claim that the old position was wrong. That is the practical significance of estoppel. And that is why the Pakistani Supreme Court's reasoning is so interesting when placed beside the Indian controversy. The courts were not necessarily saying that a human being can never make a mistake. Of course, people can make mistakes. Records can contain mistakes. Parents can make mistakes. Officials can make mistakes. But the crucial question is, when was the mistake discovered, and when was it challenged? If the alleged mistake remains unchallenged throughout an entire career and is suddenly raised when retirement is approaching, the court has a very different problem to coincide. Now ask yourself, what was different? The country was different. The institution was different. The rank was dramatically different. One was the chief of the Indian Army. The other was a government officer in Pakistan. But the judicial concern was remarkably similar. The courts were protecting something bigger than the individual claim. They were protecting certainty in public administration. Because a government service record cannot be treated like a document that can simply be rewritten whenever retirement approaches. If a person accepts a particular date for decades, if appointments, promotions, benefits, and service decisions are made on that basis, then allowing a last-minute change can affect not only that individual, but the entire structure of public service. And perhaps this is the most powerful part of the story. In India, the person at the center of the controversy was the country's army chief. In Pakistan, it was a government officer. Yet before the courts, rank did not automatically create a different principle. The law was being asked to answer the same fundamental question. Should the rules of public service change because the person asking for the change happens to hold an important position, or because retirement is close? The answer emerging from these two stories was remarkably similar. And here is where the story becomes almost poetic. India and Pakistan have had decades of political conflict. Governments have disagreed. Armies have confronted each other. Borders have been disputed. But the people on both sides of that border often face remarkably similar problems. A land dispute. A family dispute. A property dispute. A government job. A retirement problem. A disputed document. A date of birth. And even the legal systems of the two countries share a deep historical ancestry. So perhaps it should not surprise us that, in certain cases, judges on both sides of the border confront the same legal questions and arrive at remarkably similar principles. But were the two courts really on the same page? Not literally. The Supreme Court of India and the Supreme Court of Pakistan are completely independent institutions. They do not coordinate their judgments. They are not working together. But in this particular comparison, they appear to have been on the same page in principle. This is not judicial cooperation. It is judicial convergence. Two independent apex courts. Two separate countries. Two separate cases. And a strikingly similar judicial instinct. Protect the integrity of the service record. Protect administrative certainty. And do not allow a last-minute change to become a vehicle for extending service. So, was this merely a coincidence? Or does it reveal something deeper about the legal culture of the Indian subcontinent? Perhaps the governments of India and Pakistan may remain political rivals. But their people still share many of the same social problems. And sometimes their courts, too, confront the same legal questions. A powerful army chief on one side. An ordinary government officer on the other. One date of birth. Two countries. Two apex courts. And one remarkably similar message. A service record cannot simply be rewritten at the finish line because the old record has suddenly become inconvenient. Perhaps that is the real lesson. Governments may draw borders between nations. But law sometimes reminds us how much those societies still have in common. And perhaps that is the most fascinating kind of brotherhood in the subcontinent. Not political brotherhood, but the recognition that ordinary people, ordinary problems, and sometimes even the principles of justice, are remarkably similar on both sides of the border.